right, good morning. If you are catching on the live webinar, thank you so much for joining. Today, we are going to talk about Social Security disability for long haul COVID. If you are watching on the replay, we're going to talk about the same thing. Today, we're going to talk about Social Security disability basics, go into Social Security guidance, some potential listings as it relates to long haul COVID, some considerations, and then of course I end all the webinars with how an attorney can actually help you with your Social Security disability claim. A little bit about me. My name is Kaitlin Wildoner. I'm the founding attorney of Beacon Disability, which is a law firm based in Florida, focused on helping individuals obtain disability benefits as quickly as possible so they can focus on getting better. We exclusively practice federal administrative disability law, and we assist clients with their agency level matters, which is the initial application all the way through to the appeals council. If you have a question on today's webinar, or if you're watching on the replay, please remember, I cannot answer any questions live. And the reason for that is because I don't want you to put any of your personal information out there so that other people can see it or hear it. Same with on the replay. Please don't comment with any specific questions. I do provide my contact information at the end of the webinar. If you're watching on the replay, it's also down below. Feel free to reach out, call, email, however we can help. We are more than happy to do so, but please do not put any identifying information and ask any specific questions as it relates to your case. All right, so the other thing I wanted to mention before we get started is we are talking about disability for long haul COVID. We have all been in this same kind of situation over the last little over 2 years now. We're recording this in July of 2022. We kind of became all consumed with COVID in March of 2020. And so we're all learning how to navigate this together. And so included in that is the Social Security Administration. They don't have a crystal ball any clearer than ours are. They don't know what the long-term impacts of COVID will be, and we'll talk about that a little bit. But so this webinar is accurate as of right now. However, because we are continually learning about new things as it relates to COVID and long haul COVID, it's likely to change. So keep that in mind if you're not watching this within the next few weeks. It's likely that the information given in this webinar is still relevant and valid, but a few weeks from now, we might have more information that helps shed some light on this or that. So just keep that in mind as we're going through today as well. This is not something that is going to be evergreen and going to be true today and 3 years from now. It's likely that we'll have more information on what the impact of COVID and long haul COVID will be. But for right now, this is where we are. So before we get into COVID specifics, I do want to talk about some Social Security disability basics. With respect to Social Security disability, there are two different programs. There's Social Security Disability Insurance, which is SSDI benefits. Those are based on what you have paid into the system while you were able to work. In order to be found disabled under SSDI, you've got to be disabled for a period of at least 12 months, which means unable to work due to physical and/or mental impairments. Again, that period has to be 12 months. As you'll see, shifting to SSI, Supplemental Security Income, it's the same. You also have to be disabled for a period of at least 12 months, meaning you're unable to work due to physical and/or mental impairments. The difference between the two programs is what will create eligibility for them. So with SSDI, as I mentioned, you have to have sufficient work credits. It's based on what you paid in while you were able to work. With SSI, it doesn't have a work credit requirement, but instead there are income and asset thresholds that you have to be between in order to qualify for SSI. So for that, it's generally speaking, there are always going to be nuances, but generally speaking, for SSI, you have to have less than $2,000 in assets if you're single and less than $3,000 in assets if you're married. Now, importantly, those thresholds, you can own one home and one car, but anything above that is going to count towards those thresholds. Again, there are some exceptions, but generally speaking, that's kind of the rule of thumb that we operate by. The sufficient work credits for SSDI benefits, generally speaking, again, there are exceptions, especially for younger individuals, but generally you have to have worked 5 of the last 10 years. Okay. And that means work and paid into the Social Security system. If you work for example, we're in Florida. Some of our teachers, for example, do not pay into Social Security. They pay into the Florida retirement system. And so they are not always Social Security eligible because they're not always paying Social Security taxes, but sometimes they do. So it just depends. You've got to have sufficient work credits. You have to have worked 5 of the last 10 years and paid into Social Security for those 5 of the last 10 years, enough money to get your quarters of credits. If you have questions about any of that, call me, call Social Security. If you call Social Security, they should be able to tell you off the bat by looking at your file what your date last insured is for disability benefits. And that'll tell you how long you have sufficient work credits. All right. When you apply for Social Security, in order to kind of get to their finding of disability or not, there's a 5-step evaluation process that Social Security walks through. First, when they get that application, they're first going to look at, are you engaging in substantial gainful activity? And that means, are you working more than 20 hours a week? Are you earning more than $1,350 a month in gross earnings? So that's step 1. If you are engaging in substantial gainful activity, by definition, you cannot be found disabled. Social Security will stop the evaluation there and you'll be found not disabled. If you are not engaging in substantial gainful activity, they will move to step 2 and look at, okay, do you have any severe medically determinable impairments? If not, again, the evaluation stops there. You don't have any severe impairments. By definition, you can't be found disabled. If you do have at least 1 or 2 or 3, however many it is, as long as you've got 1 severe medically determinable impairment, it moves to step 3, and they look at the listings, which we will talk about in a few minutes. And do you meet or equal a listing? If you do meet or equal a listing, your evaluation stops there and you're approved. Okay. If you don't meet or equal a listing, then your evaluation moves to the next step, which is where they kind of will look at, can you go back to doing your past work? And to get to that stage, there's kind of a stage 3B. And if you don't meet or equal a listing, then Social Security creates for you a residual functional capacity. And that RFC is what Social Security uses in steps 4 and 5 to determine, okay, based on this RFC, which is based on your medical records, can you return to your past work? If not, then they move to step 5. If you can return to your past work based on the RFC that they give you, you're not disabled, you'll get that denial letter. If you cannot return to your past work, Social Security moves to step 5 and determines, using that same RFC, okay, is there other jobs, other work that you can do in the national economy with that same RFC? And if not, if there's no other jobs you can do, that's where you get an approval. If there are other jobs that you can do, then you would get an ultimate denial. Okay. All right. So shifting to COVID specifics. So when this all kind of started, Social Security started issuing emergency messages. Okay. We were all, I mean, I'm sure most of us can remember just back, what was that, 27 months, the news in my office, I had it on all the time, trying to figure out what's happening, what's going on. Are cases going up, down? Is this going to be, a really big problem? So Social Security added to that pile of messages. And here is emergency message 21032, which offers guidance from the agency about what to do if a case involves either an allegation or a diagnosis of COVID-19. The emergency message does note that what we know about it over these last 27 months, COVID has primarily been a respiratory disease. However, it can impact other body functions, such as our cardiovascular system, our renal system, neurological, psychiatric, and other systems. As I've mentioned, as you are probably aware, the medical community is still learning about COVID-19, what it means in the immediate impact upon a diagnosis, as well as what it means for those who have been diagnosed with long-haul COVID. Okay, important. COVID-19 in and of itself is not enough to meet a listing. There is no COVID listing. Okay, as we'll talk about in a few minutes, there are some listings that we can maybe shoehorn if you meet certain requirements, but there is no listing for COVID-19. So COVID-19 in and of itself is not enough to meet a listing. However, depending on many factors, it might meet a listing as a combination of impairments. So that's the important thing to remember, okay? Now, if you've watched my webinars before, you know I try not to look at notes. I try to kind of do it off the cuff because it gives us better, I think it's better interaction. However, since this is still new, I do have notes that I'm going to be looking at throughout this just to make sure we kind of cover everything that I want to cover. So with respect to this emergency message, it does also give a little bit of guidance on how COVID can be classified as a medically determinable impairment. So in order to be classified as a medically determinable impairment, you have to have a report of a positive viral test for COVID. So you have to have a positive COVID test. You can't say, oh, I think I had COVID. No, you've got to have that actual positive test. You also have to have a diagnostic test, like an X-ray, that's consistent with findings of COVID. Again, this is continuing to shift. I'm sure anybody that watched the news back in 2020 was seeing kind of some of the X-rays that they were throwing up on the screen all the time about, how terrible these lungs looked. Well, now the lungs are looking a little bit different. So that's what I mean by, this messaging is shifting as we learn more about it, as the disease itself changes. So, but in this emergency message, these are the requirements. And then you've also got to have a diagnosis of COVID with signs that are consistent with the viral infection. Again, that's changing. So what may have been consistent with the diagnosis in November of 2020 is a little bit different from what we're seeing here in July of 2022. I have been seeing, I don't really watch the news so much anymore, but I have been seeing a lot more kind of anecdotal evidence of people who are testing positive, and they're not as symptomatic as they were back in 2020. So things might be shifting a little bit, but we still don't know, even if you get COVID today in a more, a lighter version of it than what people were getting in 2020, let's say, we still don't know if it's going to have long-lasting impact. So there's a lot that we don't know still that we're still learning about. All right. There's another emergency message. It's emergency message 20060. And this emergency message more offers guidance to Social Security agency employees about what they need to be doing to flag the COVID cases. And it does make reference, this emergency message does reference to CDC publications, which can be accessed on the CDC website. There's long COVID or post-COVID conditions, and then people with certain medical conditions. And importantly, this emergency message seems to acknowledge and kind of piggyback off of the other one in that COVID might lead to complications beyond that initial respiratory disease. And I have seen in my practice where I've got clients that do have long haul COVID, or they might not have even been officially diagnosed with long haul COVID, but they were officially diagnosed with COVID in 2020 or 2021, or even earlier this year. And they're continuing to have breathing difficulties. They are having heart issues. So and it impacts everybody differently. I mean, I can't tell you that I have 2 clients that have had COVID that have the same issues. It impacts everybody differently. It depends on a lot of comorbidities, I think, in my non-medical opinion. So that is the other emergency message. And again, it tends to focus more on the guidance to the Social Security employees. The other thing, while we're on this kind of agency guidance, HHS issued guidance as well, and it's guidance on long COVID as a disability under the ADA. So it's very different from Social Security. ADA rules are very different from Social Security, but it still is kind of government advice, government guidance. It's not going to be an automatic portrayal and equivalency, but it can be kind of helpful to at least read it. And the very first thing that this guidance says is, although many people with COVID-19 get better within weeks, some people continue to experience symptoms that can last months after being first infected, or may have new or recurring symptoms at a later time. So just that first sentence, automatically, we don't know what's going on. The other thing I will say is when I have had these cases with COVID diagnoses, the judges that I have had with them. Now, every judge is different, and every judge has, the same judge can have a different opinion 2 different days. But they tend to, sorry about that, be kind of aware of the fact that, here we go. We've got this guidance from the agency that isn't totally sure what's going on. So if you've got COVID, if you've got long haul COVID, just be aware of that. Be aware that things are changing. Be aware that new guidance is being issued on a regular basis. Keep up with that. If you have a lawyer working on your case, they're probably keeping up with that, but it doesn't hurt to reach out and say, hey, by the way, I saw this new thing. How, have you had a chance to review it yet? Because if they have, then that's great. They can just say, yep, I've got it. If not, then, you're drawing their attention. We're all in this together. When you've got an attorney working on your case, you're on the same team fighting for the same result. So that's the important thing to remember. The attorney is the expert, but as this kind of stuff is shifting and changing, it never hurts to reach out to the lawyer and say, hey, just wanted to make sure. We don't ever say anything about, if you haven't looked at this yet, then you're dumb, because that's not true. It's constantly changing and shifting. So this is the kind of the government guidance, if you will. And again, there are those 2 CDC publications as well. All right, shifting into potential listings. As we've mentioned, Social Security, and by and large, I think most of the medical community, based on my knowledge and understanding anyways, I'm not part of the medical community, of course, look at COVID as a respiratory disorder. That's why we wear the masks. So here are a selection of possible listings within the Blue Book that relate to respiratory disorders. So first, we've got listing 302 and listing 303. That's chronic respiratory disorders and asthma. Those listings, if you look at them, they have charts in them, and they explain what certain parameters must be met based on, I think it's height, weight, gender, things like that. So it will look at those types of things, and the tests that are required under 302 and 303 give objective results. And that's what Social Security really likes. They like objective evidence versus subjective. So shifting to 309, that also has some pretty stringent requirements, including a pulmonary artery pressure equal to or greater than 40 as determined by a cardiac catheterization. Okay. And normal pulmonary artery pressure is 18 to 25. So it's about double, okay, to meet that listing. And then 314 is respiratory failure. And that would require you to have mechanical ventilation at least twice within a 1-year period. And those vent periods have to be at least 30 days apart. So it can happen, where if you've got COVID and so you are in the hospital on a vent, and then it comes back 6 months later and you've got to be back in the hospital, back on a vent. That's where 314 can kind of come into play. But the important thing to remember is a disability has to last at least 12 months. So after that second ventilation, you're doing fine. You're back in the community. You haven't had to go back in. You seem to be, by most accounts, doing better, maybe not back to normal, but doing better. You're going to have to start shifting thinking to, okay, what else is still going on so I can meet that 12-month duration requirement. Okay. So just a thought. All right. Moving to cardiovascular system. So Social Security has not so far really made a link between COVID and the cardiovascular system. However, according to the Journal of the American Medical Association, patients with COVID-19 were at an increased risk of broad range of cardiovascular disorders. So as you can see, it goes into a whole bunch of different conditions that if somebody has been diagnosed with COVID, now they are at an increased risk of these conditions. And I have seen that in some of my clients who have been diagnosed with COVID. They now do have issues with their cardiovascular system. And whether their doctors are linking it to COVID or not, it's still something that you can put into the case and say, look, this is ongoing. And whether it's a direct link to COVID or not, we're not sure yet, but there does seem to be some evidence that it might be. Cardiovascular things, as you can see, they're in section 4 of the Blue Book. And it's important that if you do have issues with your heart post-COVID, to go ahead and look at that and to maybe make some considerations there. Also, Social Security does not have a direct link between COVID and musculoskeletal pain. However, according to the National Institutes of Health, more than 15% of COVID patients do have myalgias and arthralgias of muscle and joint pains. So this sometimes can come into play too, if you think about it. If a patient is hospitalized with COVID-19 for an extended period of time, and so they are on a vent for 30 days, 60 days, whatever it is, 2 weeks even, and they're not able to get up and move, that can lead to a physical decompensation, which might lead to musculoskeletal issues. So think about it from that perspective as well. Not everybody I would think this goes without saying, but maybe not. Not everybody with COVID has experienced the same situation. So that's the important thing to remember. Just because we're talking about these does not mean that because you had COVID, you're automatically going to have heart issues or you're automatically going to have pain. No, it's just these are some of the side effects. And so some of the other things you may want to consider if you have an active claim that involves COVID. Okay, certain considerations we want to take into account with COVID cases, really any cases, but especially COVID cases. Medical records are critical. As I've mentioned, the listings for the respiratory disorders heavily rely on those medical records, as do the other listings. But because COVID has primarily been a respiratory disease, those are the ones that we focused on a little bit and called out some specific listings. Medical records are critical. Objective medical records are best. As I said on the last bullet point, getting ahead of myself. Again, the issue in Social Security cases is not just can you go back to your past work, but can you perform any job that exists in the national economy? Once you hit 50, grid rules might apply. I have done webinars on the grid rules before. If you are 50 or older and then 55 and older, go back and watch some of those, as those can be helpful. And if you just have 1 or 2 specific questions about it, reach out to us. Happy to help, happy to answer your questions. The other thing to remember is, in addition to listings, in addition to the grid rules, functional capacity can also be relevant. If you are no longer able to sustain competitive employment, why? What is going on that is preventing you from engaging in any kind of competitive employment? Talk to your doctor about that. See if they can put that in the medical records. All right, how can an attorney help you? Again, we provide guidance on what correspondence from Social Security actually means. If you hire us in the correct time frame, we can file necessary appeals. We do review your medical records in your case file. We discuss what additional records could be helpful in your case. We review documents for accuracy and completeness. We discuss with you what Social Security is looking for in their requested forms to hopefully get you to that point of accuracy and completeness. We work with you to provide relevant updates to and from Social Security throughout your claim. If you've got updated medicals, you give it to us, we give it to Social Security. If they're calling, telling us, hey, we're having a hard time getting these records, not only do we jump in and try to help and resolve it, but sometimes we reach out to you because you might have it. You might either have the records already, you might have access to the portal. It's important to remember, again, when you've got an attorney working with you on the disability case, we're all on the same team. So we're all pushing towards that approval. We're all working together. That's important to remember. If you have an attorney at the hearing level, some of the most important things that they do is they prepare you for that hearing, and then they question you and any other relevant witnesses, such as a vocational witness or a medical witness, during that hearing. All right, so as I mentioned at the beginning, I do not take questions on the live webinar. I do not respond to questions on the replay. If you do have questions, please call or email. This webinar can't constitute legal advice because I don't know your specific situation. If you call or email and get us, get in as a client, that's when we can start providing legal advice. These webinars are just provided as some general information to help kind of point you in certain directions of where you may want to look for more. Again, if you have any questions, please feel free to reach out. You can give us a call, send us an email. Happy to help in any way that we can. Thank you so much for joining us. Have a great day.